Hi, I'm Milton Lawrence, and today we have a distinguished panel of experienced attorneys with specific expertise in all areas of mortgage lending abuse against homeowners. And during today's show, we'll be providing you with all the information you need to protect your rights as a homeowner. Joining me on the show today, attorneys Kenan Spivak, Ted Maloney, Darren Colby, and Vito Torsha Jr. Gentlemen, thanks for joining us on our show today. Let me start out by asking you about your background and experience. Ted, let me start out with you.
Okay, my background is I've been a corporate and transactional lawyer for a little over 25 years. And my background includes banking, corporate finance, and an area of particular interest to the subject matter we're talking about today, which is securitization, and have primarily spent time on that until we joined in the Ronald case.
Kenan?
Thanks. For the last 30 years, I've run the gamut from being chief executive officer of some very large companies. I was an investment banker at Merrill Lynch, and I've been an attorney. About a year ago, I got involved in what's become the lead case trying to protect the rights of homeowners, and I'm lead counsel now in that case. And so I've been spending quite a bit of time trying to work my way through the issues and the means of protecting homeowners.
Darren, tell me about yourself.
Thank you, Milton. I started practicing law about 14 years ago. Started in the securities corporate area, business litigation, so I've been doing business litigation for about 14 years now, and got into this area of law just recently with what they call the mortgage meltdown. Consider myself somewhat of a blue-collar lawyer in terms of understanding clients' issues, and I think it serves me well in the area of law that I practice currently, and that is trying unlawful detainer actions, handling individual lawsuits. I meet with every client. I listen to their stories. Some of their stories are very compelling, very heart-wrenching. And so my focus right now is litigation in the trenches in the courtroom.
Very well, and last but never least, Vito.
Hi, Milton. My experience ranges about 50% transactional, 50% litigation. I'm licensed in California, New York, and Florida, and have multiple mass tort actions going on in California at this time with regards to the lending industry.
We are interrupting our program to inform you of a groundbreaking court decision in California as reported by CNN. In a recent ruling against Bank of America, it's been made possible for over 2,000 homeowners to be heard in court by Brookstone Law. This case is based on the allegations that major U.S. banks engaged in a massive conspiracy and fraudulent scheme to place borrowers into loans for which they were unsuited. Now, back to our program.
Let's get right into it. Let me ask you, in your opinion, what actually caused our housing crisis?
I think the housing crisis was caused by a number of factors, and certainly one which is germane here, and a very large one, were the practices by a lot of the largest banks in the United States of giving mortgages to consumers who they knew could not afford those mortgages, giving them those mortgages not with the purpose or intention of being engaged in the mortgage business, but rather to use the mortgages as fodder for the sale of securitized, collateralized mortgage obligations. That sale itself is not wrong, but it is wrong when the banks fail to tell their investors that the loans that they are putting into these pools are not prime loans, but rather were subprime loans. That fraud, or apparent fraud, and in some cases admitted fraud by the banks on investors, led to a liquidity crisis because the investors no longer trusted the banks, wouldn't purchase the collateralized mortgage obligations. Mortgages couldn't be refinanced. Banks didn't have the money to give loans. Prices started falling. Consumers couldn't afford their mortgages. Mortgage availability dried up, and housing prices plummeted.
What I see is a lot of people were misled with respect to the products they were getting into, and I call it feeding the machine. The goal of the mortgage industry was to feed this machine, the securitization of loans, and so they came up with new products like pick-a-pay loans, like they call them actually in the industry liar loans, neg-am loans. They were creating all these brand new products in order to feed the machine, feed Wall Street. And in doing so, many homeowners were led into loans that they could not afford, that they frankly did not understand. I believe a lot of these people that when they signed these loans, they had no idea the payment was going to go up double, triple, quadruple in the third or fourth year of the loan.
Sounds like it certainly has been a tangled web to say the least, with this problem. Which leads me into our next question for you. How has this unfairly affected homeowners, the thousands and thousands of homeowners out there?
Well, if a homeowner has a mortgage and the value of the homeowner's house has declined below the value of the mortgage, and the homeowner, because of overall economic conditions, is no longer earning what the homeowner once earned, and if the monthly payments on what was a variable mortgage have now risen, the homeowner can't afford to pay the homeowner's payments. The homeowner can't refinance the mortgage and can't refinance it for a number of reasons. One is the house no longer has sufficient value to get a mortgage, and second, the mortgage money may not even be available because of the liquidity crisis, even if the house was still of the same value. And this all comes back to the fact that the banks exited the business of being mortgage lenders and entered the business of providing mortgages to feed this machine of collateralized mortgage obligations. And so the homeowner really is paying the price. We're here to try to protect the homeowners who individually can't afford to bring these cases. But when they get together in these joinder cases, they can then afford to do so.
We are interrupting our program to inform you of a groundbreaking court decision in California as reported by CNN. In a recent ruling against Bank of America, it's been made possible for over 2,000 homeowners to be heard in court by Brookstone Law. This case is based on the allegations that major U.S. banks engaged in a massive conspiracy and fraudulent scheme to place borrowers into loans for which they were unsuited. Now, back to our program.
Now, earlier on our show, our law panel covered the history of the mortgage crisis and the effect it's had on homeowners all across the country. In this segment, we'll be discussing the specific abuses by lenders that our panel has uncovered that can affect your rights as a homeowner. Let me ask you, what are the primary problems that all of you have found with practices of mortgage lenders that can negatively affect homeowners?
Well, let me tell you what the lender's approach is when they approach these cases. Lender's approach is, despite anything that may have happened with our recorded documents, as long as we fix it before we foreclose on you, judge, ignore everything that happened. So in my experience, I see documents that are out of order. I see missing documents. I see trustees that are taking acts to foreclose that haven't been substituted in. I see beneficiaries that are recording notices of default or notices of trustee sale that haven't actually been assigned the deed of trust. And so I go in and I argue that these documents that should have been recorded that aren't recorded, they need to record these documents because they don't have a right to foreclose. Sometimes, believe it or not, the party in court that's attempting to foreclose on our clients doesn't actually hold the note or have the right to foreclose on the homeowner.
About 2 months ago, just about every major financial agency of the U.S. government got together. The Treasury Department, the FDIC, the Office of Thrift Supervision, and they forced the leading banks in the United States to sign consent decrees. And together with the consent decrees, there were findings. And those findings included lack of signatures on documents necessary for the chain of title. The findings included robo-signing. The findings included weak control systems in which affidavits may have been signed under oath that may not have been true. The findings were that the use of an entity called MERS, which is a entity formed by the banking industry to try to take the assignment of deeds outside of the normal county registration system, may have had defects. And in these consent decrees signed with the federal government said that it was requiring the banks to supply considerable additional information because it might force the banks in some cases to give money back to homeowners where there had already been foreclosures. So the federal government has recognized, and the banks through these consent decrees have recognized, that there have been massive defects in the system from the initial recordation of the loan to the purported assignment of interests in those loans as part of the collateralized mortgage sales, or the purported assignment of servicing rights in those loans that in many instances are not backed up by the proper documentation. And the laws in most states and federal laws in most instances require that in order to foreclose on a loan, the bank or the servicing company foreclosing has to prove that it actually owns the loan or has a valid right to foreclose on the loan. And it's usually supposed to show that by showing contemporaneously recorded documents. Now, there are exceptions, and that's why I use the word generally, but the problem is severe and pervasive enough that the federal government has gotten into this act in a very major way. This is a very large problem, a recognized problem, but it's only part of the problem.
I was just going to add, because Kennan's practice in this area focuses mainly on the mass tort actions. My practice focuses more on the unlawful detainer defense and individual lawsuit type situation. And so in the individual lawsuit, the other approach that we take is some of these people, when they got into financial hardship, they went to the lender to try to seek relief. They were what I call led down the rosy path. And that is, they were led to believe by the lender that they would get a permanent modification of their loan, while in some instances the investor on the loan, the person calling the shots as to whether the borrower gets a modification, they have a contract with the servicer that says they cannot modify the loan, and the borrower's never told this. So they're led to believe if they make trial payment plans on a trial modification, that at the end of the day, at the end of the trial modification, they'll receive a permanent modification. Well, a lot of these people faithfully paid on their trial plan. They were put into this circus, I'll call it, of mod review, providing financial statements. The lender rep loses documents. They say they never received documents. So it's sometimes months upon months upon months of going around in circles and trying to get a modification and making these trial modification payments, and then they get a denial letter. And we find out at the end of the day, they never could have got modified to begin with.
We are interrupting our program to inform you of a groundbreaking court decision in California as reported by CNN. In a recent ruling against Bank of America, it's been made possible for over 2,000 homeowners to be heard in court by Brookstone Law. This case is based on the allegations that major U.S. banks engaged in a massive conspiracy and fraudulent scheme to place borrowers into loans for which they were unsuited. Now, back to our program.
How can these problems then be addressed, and what effect can a homeowner expect if this panel's efforts are successful?
And so I'll speak to what Ken said earlier, and that is we do have different areas of practice. And so our goal, or my goal, when I take on a client is typically they're facing foreclosure, and they've tried to get a modification, they haven't been able to get a modification, and so they're looking for some sort of relief. In conjunction with attempting to get immediate relief, we also add in claims that would, in my opinion, make the homeowner whole. But the immediate goal is to get relief because they're facing foreclosure. So we go in and we attempt to get what's called temporary restraining orders. And we have to have really compelling evidence to get restraining orders, and I'll echo what Ken said earlier, and that is there's no guarantee. In fact, the climate in California courts is not to grant restraining orders, but thankfully we've been successful in obtaining a couple of restraining orders. In fact, we were just issued a preliminary injunction recently on a case that we're working on. And so it is immediate relief. It is attempting to stop the foreclosure. And if we can stop the foreclosure, then we can work with the lender and attempt to work out some sort of a settlement, or we take it to the end of the road and we litigate it. So, but there are, even in my context and my area of practice, there are claims that are added in to attempt to make the homeowner whole at the end of the day.
Specific conditions that qualify a homeowner for participation in this program? Anything very specific?
With respect to my area of practice, yeah, what we do before we accept a client, because I'm not in the business of taking legal fees from somebody that I don't feel like I can honestly help. I sit down with them. Before I consult with them, I review all their recorded documents. Sometimes they get what's called a securitization report, which tracks the securitization of, I won't bore you, but securitization of the loan, and then at the end of the day, whether the party in court that's attempting to foreclose has that right. And so we review as much information as we can, and then I sit down with the client and I talk to them about their experiences with the lender, their experience in attempting to get a modification. And so it is a very client-specific, fact-specific analysis that occurs. And then if at the end of the day we think we can help this particular client, we tell them what the costs, the risks, the benefits are with this particular approach, and then they make a reasoned decision as to whether they want to take that shot. And again, as Ken has said several times, and I echo, some people want to just give up, and I understand that. But a lot of people, they've put their blood, sweat, and tears into their house, and they don't want to give up. And even though they know there might be a slim chance that we get a restraining, or there might be a slim chance that their complaint survives, they still want to take that shot.
So in the mass actions, there are time periods, and broadly speaking, it's the mid-2000s, when the activities of the banks led to what ended up being the mortgage meltdown. And so largely, and not exclusively, but largely for mass actions that are currently underway, consumers or homeowners need to have obtained a loan during that period, and then they are, broadly speaking, eligible to participate in protecting their rights and seeking remedies.
When we come back, we'll answer more of the questions you may have, as well as talk about how a call to a qualified attorney can be the most important call a homeowner with mortgage problems will ever make. Stay tuned.
This is an important announcement for anyone in America who currently is in danger of losing their home due to foreclosure or other related actions of their lender. If this sounds like you, we have great news you'll want to hear. And that news is that there is help available to you now. Help available because in many cases, lenders have been found guilty of illegal lending practices or other wrongdoing. If this has happened to you, litigation handled by a qualified legal representative may keep you in your home. Brookstone Law has a team of experienced, complex business litigation attorneys that can help people victimized by violations of a wide range of consumer protection laws. We at Brookstone Law prosecute cases where banks, loan servicers, or others have taken advantage of honest homeowners. Brookstone Law also offers a unique service not offered by any other firm. Brookstone Law's Emergency Extension Department gives homeowners facing foreclosure a real chance to stay in their homes while they're in the process of litigation, bankruptcy, or short sale.
Once we contacted the team at Brookstone Law Firm, things started getting better. Things were more optimistic. We could pretty much afford a smile. And the good thing about it is we always got constant feedback. We always had an attorney calling every other day or every day if it had to be, much as maybe 2-3 times a day, giving us progress on our report, progress on our situation, on our case. And it's always good to know that someone out there looking out for you. All I can say is it's very promising, and the whole team of attorneys down at Brookstone have done a tremendous job, and I'm confident they'll pull it off.
The attorneys at Brookstone, and we've met several of them, and their assistants have been helping with us with our case, and we're very satisfied with them.
Our attorney, Mr. Colby, has been doing a great job, really, because since he got involved, all this harassment has stopped a lot. He's on top of our case, and he's working very hard for saving our house, which is the important thing for us.
Don't be forced out of your house by the banks. You have rights, and Brookstone Law will do everything possible to help you save your home. Time is not on your side, so now is the time to call Brookstone Law. Don't wait. Call now.
Thanks for staying with us. During this segment of our show, we're going to answer more of the questions homeowners typically have and talk more about the current regulatory environment, how it can affect your rights as a homeowner, and how you can get help.
We are interrupting our program to inform you of a groundbreaking court decision in California as reported by CNN. In a recent ruling against Bank of America, it's been made possible for over 2,000 homeowners to be heard in court by Brookstone Law. This case is based on the allegations that major U.S. banks engaged in a massive conspiracy and fraudulent scheme to place borrowers into loans for which they were unsuited. Now, back to our program.
Darren, what are some of the most common questions troubled homeowners have out there?
Some of the most common questions people have, because most of these people have been through what I referred to earlier as the circus of attempting to get a modification, is why didn't I get a modification? And some of the most common reasons are, well, some people just don't financially qualify for a modification. Their finances just don't support any type of mortgage payment. There's those people. But there's a lot of people that went through, as I discussed earlier, the trial modification, and then at the end of the day they get a denial letter and they ask me, why did I get denied? And usually it's because the investor on the loan doesn't allow modifications, or there's some limit with the servicer. They have a contract. The investor has a contract with the servicer, and that limits the number of modifications that they can get. So these people are typically extremely frustrated. They have questions regarding a notice of default. What is this notice of default? How much time do I have to respond to it? When is my sale date going to be set? So I explain to them the timing in California with respect to foreclosures, and that once a notice of default is filed, then 90 days later you can expect a trustee sale or sale date on your home to be noticed, and then that'll be, this actual sale date will be about 20 days from there. And then what happens after my home gets foreclosed on, and that's where the unlawful detainer or eviction action is filed. So obviously, I can't overstate this, but people are very, very anxious. They're about to lose their home. So they're very emotional, and I feel like it's my job to just clearly explain the timing. A lot of people think when my house is foreclosed, I have to move out that day, but typically it's 30 to 45 to sometimes 60 days and greater before they actually have to move out of their house in the worst case scenario. So I just try to answer the client's questions in the most plain English way so that they can understand exactly what's going to happen and when it's going to happen. And then the costs. A lot of clients, they're in financial distress. This is why they're here. This is why they haven't been able to pay their mortgage, so they want to know what the costs associated with litigating either an unlawful detainer action, a mass tort action, or an individual lawsuit. And at the end of the day, like I said, I want to make sure that they get all the facts, they ask all their questions, and then they make a very reasoned decision as to how they want to proceed.
You know, there's a lot of information about cases out there, and we certainly have touched on that today. Can I ask you to elaborate a little bit on what a joinder case is and what is a class action case? What's the difference? Maybe you can kind of explain for us.
Sure. The Ronald case and the other cases that we've talked about that are these longer term cases for homeowners are joinder cases. These are cases in which we have a lot of individual plaintiffs. And the reason we have a lot of individual plaintiffs is parts of these cases are the same for all of the plaintiffs. Whether concealment is or isn't a valid cause of action, whether fraud is or isn't a valid cause of action, what type of information the bank published or didn't publish. These are more or less the same for all of the plaintiffs. But then there are a lot of facts that are very fact-specific. Some of the fraud facts would be very fact-specific. What did your bank officer tell you or not tell you? Or that might be different for every plaintiff. The damages are different for every plaintiff. And so a joinder case is a case in which a great deal of the facts and issues are in common, but then there are other facts and issues that are not in common. And in a joinder case, each client has individually hired the lawyer, and the lawyer then proceeds and goes on with the case. In a class action, really the lawyers start the case. And they may find one client who's indicative of the other clients in the case, but everyone has the same facts. The clients have no lawyer to call up. The lawyers won't talk to the clients. The lawyers do the case. The lawyer's their own client, really. And it wins or it loses. In the end, there's a recovery. The lawyers usually get most of the recovery. The balance goes to the various members of the class. Technically, the lawyer may only get a quarter or a third of the recovery, but then the rest goes into a pool, and individual members of the class have to actually apply for the money. Few do, and in the end, it's good for lawyers and maybe sometimes good for clients. Joinder cases, the lawyers may get a contingency fee, maybe 20, 30, 40%, but the rest really does go to their clients. The one difference about a joinder case that's important and that some clients don't like, but it's a sad fact of reality, is that in most joinder cases, including most of the cases involving with the bank problems, in most joinder cases the clients are asked to pay a few $1,000s up front to help defray the costs, and then most of the costs are reimbursed only in success and the fees are paid only in success, but they are asked to pay a few $1,000s, and the sad reality is these are expensive cases, and not many lawyers would have the financial capacity, nor would it be a particularly good business decision, quite honestly, for a lawyer to spend many, many hundreds of thousands of dollars, take all of his time. And these cases involve not one lawyer, but teams of lawyers, and in the end not only perhaps lose and get nothing, but have lost hundreds of thousands of dollars in the effort. So these upfront payments are meant to change the equation at least a little bit, so that the lawyer, if the lawyer should lose, may still lose money, but not as much money But the lawyer is in the case not for the few $1,000s up front, but for the recovery at the end. In a class action, clients never pay anything up front, and as I said, they often don't get very much in the end.
Well, unfortunately, we've just scratched the surface, and there's so much more information. Unfortunately, we are out of time, but we certainly have come a long way, I think, in educating our viewers today on the crisis out there and what they can do. So I want to thank our distinguished panel of attorneys for joining us today. Thank you very much. And if you'd like more information on the mortgage crisis and what you can do, call the number at the bottom of your screen. Thanks for watching.
We are interrupting our program to inform you of a groundbreaking court decision in California as reported by CNN. In a recent ruling against Bank of America, it's been made possible for over 2,000 homeowners to be heard in court by Brookstone Law. This case is based on the allegations that major U.S. banks engaged in a massive conspiracy and fraudulent scheme to place borrowers into loans for which they were unsuited. Now, back to our program. This is an important announcement for anyone in America who currently is in danger of losing their home due to foreclosure or other related actions of their lender. If this sounds like you, we have great news you'll want to hear. And that news is that there is help available to you now. Help available because in many cases, lenders have been found guilty of illegal lending practices or other wrongdoing. If this has happened to you, litigation handled by a qualified legal representative may keep you in your home. Brookstone Law has a team of experienced, complex business litigation attorneys that can help people victimized by violations of a wide range of consumer protection laws. We at Brookstone Law prosecute cases where banks, loan servicers, or others have taken advantage of honest homeowners. Brookstone Law also offers a unique service not offered by any other firm. Brookstone Law's Emergency Extension Department gives homeowners facing foreclosure a real chance to stay in their homes while they're in the process of litigation, bankruptcy, or short sale.
Once we contacted the team at Brookstone Law Firm, things started getting better. Things were more optimistic. We could pretty much afford a smile. And the good thing about it is we always got constant feedback. We always had an attorney calling every other day or every day if it had to be, much as maybe 2-3 times a day, giving us progress on our report, progress on our situation, on our case. And it's always good to know that someone out there looking out for you. All I can say is it's very promising, and the whole team of attorneys down at Brookstone have done a tremendous job. And you know, I'm confident that they'll pull it off.
The attorneys at Brookstone, and we've met several of them, and their assistants have been helping with us with our case, you know, and we're very satisfied with them.
Our attorney, Mr. Colby, has been doing a great job, really, because since he got involved, all this harassment has stopped a lot. He's on top of our case, and he's working very hard for saving our house, which is the important thing for us.
Don't be forced out of your house by the banks. You have rights, and Brookstone Law will do everything possible to help you save your home. Time is not on your side, so now is the time to call Brookstone Law. Don't wait.